Well, the facts that you need to prove are those that are both relevant and contested. And under the rules of procedure, subject to limited exceptions, you have to produce your evidence in support of an allegation of fact in the first pleading you lodge at the court, which is either the application or the defence. The rules say that evidence is either produced or offered. Production of evidence means that it is actually attached to, in some way, to the pleading and lodged at the court. And that really means that evidence that takes a documentary form can be produced to the court. In rare cases, things are produced, such as in a tariff classification case, the object that is the subject of the classification decision. Evidence is offered when the party indicates a source of evidence that he can't produce physically to the court, or can't produce it voluntarily and without a court order. The latter situation applies to, for example, secret or confidential material. When evidence is offered, basically it should take the form of a request for the court to order a measure of inquiry. That is to say, the evidence is to be produced to the court pursuant to a court order. It's very time-consuming and laborious to try to get the court to make an order. So sometimes, in the case of witness statements and experts' reports, what a party does is to convert the witness evidence or the expert's report into a document that is annexed to the pleading. That has the great advantage of indicating to the court and the opposing party what exactly the evidence is likely to be and how relevant it is. If it's only of peripheral relevance or duplicates other evidence, the court may decide not to take matters further so far as that witness or that expert is concerned. Now, technically, the problem with producing evidence of a witness or an expert in the form of a document attached to a pleading is that the evidence hasn't been brought into existence in accordance with the safeguards that apply under the rules of procedure to witness evidence and experts' reports. For example, a witness normally gives his or her evidence directly to the court and can be cross-examined by the court or by the party's representatives. And that doesn't happen where the witness produces evidence in the form of a statement annexed to a pleading. And therefore, in some respects, this method of producing witness evidence or experts' reports to the court is a kind of evidential backing for an application to the court to make an order for the production of the witness evidence or expert's report. If the court doesn't go down that road, it doesn't mean that the statement or report annexed to the pleading hasn't got any probative value at all or doesn't constitute admissible evidence. It can be used. The difficulty is that it doesn't have quite the same probative value as if it had been produced to the court pursuant to a court order.